Thank you. And thanks very much to GLG for hosting us. So as mentioned, this panel is about mass torts. We have some US practitioners and practitioner from the UK, so that's going to be our primary focus, but we'll talk a bit more about cross-border impacts as well. As mentioned, I'm Loree Kovach, Senior Vice President with Epiq. We're a global legal services company. Our division does class action and collective action settlement administration. We're working in many of the largest cases in the US, Canada, a large number of claims before the CAT in the UK, and historically we've worked in the Netherlands as well. I'm going to turn it over to my panelists to start off and introduce themselves, and then we'll get going. Debbie?
Okay. Hopefully you can hear me. Okay, I can tell that it's working. Okay. My name's Deborah Greenspan. I am a partner at Blank Rome Law Firm in Washington, D.C. My background and basically my entire career, I think, has been in mass claims, in some aspect of mass claims, and that includes class actions, multi-district litigation, and a fair number of mass tort bankruptcy cases. To the extent that I've litigated, it's been more on the defense side, but I do a lot of neutral work and have had a lot of court appointments as a special master, as it's called in the U.S., and in that capacity have done a lot of work with fashioning settlements or reaching settlement, fashioning settlements, designing how settlements can work in the mass tort area, and then making sure they get implemented appropriately. And then just a sense of the kinds of cases that I've worked. We've talked a lot here about consumer cases. That is not the type of cases that I've typically worked with. They're more like toxic exposure cases or traumatic injury cases and things like that. So that's more of my background.
James?
Hi, I'm James Brady-Banzet. I am a partner with Cleary Gottlieb in London. My practice, it includes representing clients on the defence side before the UK High Court in class action and group action cases, and also the Competition Appeals Tribunal in collective proceedings. I've also done some work in the past with investors in claims, helping them to assess and make decisions about whether and how to make investments in class actions in different jurisdictions.
Joshua?
Hi, everybody. My name is Josh Neuman. I'm a partner at Pogust Goodhead in our U.S. headquarters in Philadelphia. I work almost exclusively on mass tort and products liability cases, almost always on the plaintiff side. And we do a lot of that work in multi-district litigations, which we'll talk about today, and other coordinated or consolidated litigations in the U.S.
Thanks. So some of the earlier panels touched a little bit on the procedural process for these types of cases, but I think this is a good time just to start us off to go into that a little bit more detail. So Debbie, you want to get us started just talking a bit more about procedurally how mass torts are handled in the U.S.?
Okay. Well, I think there's been a lot of discussion about class actions and what we sort of heard yesterday about Rule 23 and how what the procedures are for how you get a class certified and how the certification process is so significant as you move forward with the case. I wanted to mention one thing that I don't know that anyone has touched on, which is an issues class, which is another component of Rule 23 where you can certify certain issues for class treatment, which gets you around, in some cases at least, the issue of trying to present a damages theory at the outset of the case. And it is a tool, and it is something that's at least I've seen implemented in a couple of cases that have been successful. But I think really we should focus on multi-district litigation, and I also think we should touch on the bankruptcy piece. Did
Absolutely.
You want me to talk more about?
Yeah, you can talk more about both.
Okay.
And Joshua can chime in.
Okay. So multi-district litigation, I think it's an older statute. It was enacted in the 1960s to kind of create this process in the federal court system in the United States. I think it just became used more frequently when the Supreme Court kind of limited the use of class actions or at least it's been perceived that way, to limit the use of class actions in certain kinds of sprawling mass tort personal injury cases, because like on a nationwide basis where there are so many differences in the types of claims or the law that might apply. And so we have multi-district litigation, which is under the rules, if there are claims, if there are cases that are filed in different jurisdictions in the country and they present basically the same factual situation, then you can ask the panel on multi-district litigation, which is a group of 7 judges appointed by the Chief Justice of the Supreme Court, to consolidate those cases in a single jurisdiction. And so that's been a tool that's really been used quite frequently in the U.S. to deal with mass claims. So these cases get consolidated in a jurisdiction that the panel selects. They pick the judge and they pick the jurisdiction that these cases are going to be handled for pretrial purposes. They're not handled there for all purposes, but it's the pretrial process that is handled by the multi-district litigation court, the transferee court, basically. And there's a lot that can happen at that phase. There's coordinated discovery, which is really made more efficient than having discovery occur in multiple different jurisdictions at the same time. You can have pretrial motion practice that really kind of sets the stage for future trials when they go back to their transferor courts. You have potential for bellwether cases being selected, which someone talked about briefly yesterday. I think there could be, you could expand on that a little bit more. And all of this, what's developed in the pretrial process eventually goes back, if the cases end up going to trial in their original courts, the original jurisdictions where they were filed, then these determinations can all be used, or are all used, in those cases going forward. What really happens for the most part is, because you've got everyone in the same jurisdiction, you've got all these cases corralled, it sets the stage really for settlements, and there are a lot of settlements that come out of MDL cases. This accounts for about 65% of the caseload, the civil caseload in the United States federal courts, the cases that are in multi-district litigation courts. It's very significant. There's some major mass tort cases that have been handled that way, but I do want to emphasize that it only applies to federal courts, so there are often a lot of state court cases in other places that have the same exact situation, so it creates kind of a two-tiered system there. Maybe I should stop there and let others chime in.
Sure. I mean, Joshua,
Yeah.
is there anything you want to add to that?
No, I thought that was great. I mean, the one thing I'll say is I was at a bench bar conference last week for the Eastern District of Pennsylvania, and a lot of people think, oh, tons of filings in federal court, judges won't like that. They love it. It's the total opposite. They love it because how the federal bench in the U.S. coordinates resources is based upon number of filings, and so we have Eastern District judges, and Judge Mitchell Goldberg, who's the head of the bench there, he's saying, look, guys, keep filing. Like Ozempic is one of the cases in the Eastern District. It's a newer MDL that was positioned there, and he wants people to file more cases. It means more money for the court system. So it's kind of opposite of what people would normally think. So the bench does enjoy these MDLs. They want more MDLs.
Yeah, that's an interesting call out to make. So James, over to you. I mean, we touched on the GLO mechanism a little bit in earlier panels, but I think that and any other procedural overview of how mass torts are handled in the UK would be great.
Sure. I think probably the place to start is that the terminology is pretty new to us in England. We haven't traditionally spoken about mass torts in the way that you do in the US, where there's a fairly established understanding of what that means. The way I think about it is claims with many claimants bring a tortious cause of action, but that can overlap into the product liability issues discussed on the previous panel, for example, where the claims are deceit claims or whatever. So the way they come forward procedure in England is typically under the GLO process. That's a very old process that's been around for many, many years and isn't designed and hasn't been adapted at a rule-based level to deal with the types of claims that are now being brought under those processes. And it works by essentially consolidating very large numbers of individual claims into a single stream of cases that are managed together. But how they get managed together is really up for grabs in most cases. There are some techniques and methods that are beginning to be established, bringing them all together, then selecting some lead cases to move forward, for example. But how that is done in each case, which cases are selected, is not something that has been very deeply explored yet in England. I'd say also that the development of the process and the claims that have been brought recently with very large numbers of claimants have led to some judicial thinking and creativity about how do they get all these cases to work in a system that fundamentally isn't really built for it. So we've seen procedural innovations like courts appointing managing judges and then holding progress meetings with the parties every couple of weeks to make sure everything's on track, that it really is quite unknown in mainstream commercial litigation in England. And we've seen the court asking for more resources and asking for bigger courtrooms and things like this. So.
It's really interesting. Debbie, did you have something to add to that?
Yeah, I just wanted to add that it's something that's in a multi-district litigation. It's not mutually exclusive. Class actions can occur in multi-district litigation, and in fact, you can get a class settlement out of the multi-district litigation, which has the effect of binding all of the cases if you can achieve it. And that's basically what happened with the PFAS settlement that I think somebody mentioned yesterday, or maybe earlier today, which is a case involving that particular settlement is municipalities seeking damages for the cost of cleaning up and the PFAS contamination in the water systems. Now, those settlements, they're only the tip of the iceberg, but there were very substantial ones, but they were done as a class within the MDL case.
Yeah, actually, if I can add to that.
Yeah.
So the JPML hearings that happen every 2 months, the next one's December 5th in Southern District of New York. So they happen across the country. If you look at the list, the case list, it's like half of it's patent cases that are all, you can see if one pharmaceutical company suing 75 other pharmaceutical companies over patents. So it's really not just like the mass tort, like MDLs are used for a whole wide, that reminded me when you said that.
Yeah.
Yeah. They're two very different regimes then. We've got one that's pretty well structured and been around for a while, very mature, and one that's really just forming, it sounds like. So I think we want to touch a little bit on cross-border issues with these types of cases. So Josh, I'm going to kick it over to you. I know you've had some cases you've handled that have had to deal with defendants outside of the jurisdiction, the country in which you're operating. Do you want to talk a little more about that?
Yeah, so I'm working on a case right now that I feel like a lot of people don't know about and many firms don't know about. It's called Esri Care. It's an artificial tears case. They were contaminated at a facility that was manufacturing them in India. They were then shipped to the United States by the company Esri Care and then distributed across the country via online marketplace or in-store retail. This is not an MDL. There are a lot of cases, though. My firm, I think we had at one point 50 plus cases. The issue in this case is from not really from a liability perspective, it's from a damages perspective. So the company in India that was manufacturing the drops, we've tried to serve via Hague service, which everyone knows that's how you serve a foreign entity in the United States. And they essentially just disappeared overnight. The FDA had essentially stormed the campus where they had this manufacturing facility, and they found a whole host of violations. But because of the laws in the United States and the fact that artificial tears are generally recognized as safe and effective by the FDA, this company was permitted to sell these drops, unhinged. There's no ramifications whatsoever. There's never any testing done. Even Esri Care said they didn't know about the issues with the manufacturing facility. The problem becomes, who do you hold responsible? Because you have clients who have died from a Pseudomonas infection. You have people who lost their eyes, horrible injuries, and it's coming up more and more in every single case. These cross-border issues, because products sold everywhere are manufactured in places like China or India, where it's very difficult to hold a company responsible. So that's some of the work, we're doing at the firm right now, navigating those issues.
Yeah, James, I see you nodding along. You have similar experience at all?
I was thinking about how cross-border issues come into it in the English context. I think what we've seen is, particularly in the environmental space, a very large, maybe not a large number of cases, but a number of significant cases brought against English parent companies in England, but focusing on the rights and remedies available to overseas nationals about, it tends to be environmental issues, oil spills or damage to resources and farmland, committed down the corporate structure or elsewhere in the supply chain, where the parent company is in England and is brought into litigation because of things it has said or responsibilities assumed towards those people elsewhere in the world. And the English courts are, very flexible and have a very wide view of their own jurisdiction. And those cases have largely met with success in terms of being able to pursue them in England. The English courts are, very willing to look at other legal systems and form an opinion on whether or not people can get substantial justice there. They look at whether funding's available and this kind of thing. And if they're not persuaded that people can get justice in other jurisdictions, the English courts are quite happy to bring those foreign issues before the English judges. So, yeah.
I think that's a really interesting concept. I mean, Debbie, do you think the U.S. courts consider access to justice in other countries when deciding whether to allow foreign claimants?
In foreign claimants into the
Yeah.
United States? I think that can be a factor. I did have a very long time ago experience with just that situation, with trying to, luckily the case ended up with a settlement, so it was easy to bring people into it. But I did want to make one more comment, in a case I'm working on right now, not on either side, but as a neutral. One of the defendants in the case has a parent company in France, and there has been a huge battle for years in this case trying to get discovery from that company because of the blocking statute, which basically, is intended to prohibit or to protect companies in France, and I think other jurisdictions have similar statutes, but from getting embroiled in U.S. litigation. And so it's been there's been just a very long discovery battle in this case, just trying to get not even that much information, but it's been quite interesting to watch how all of the pieces go forward. Actually, they never got the discovery. The plaintiffs never got it in this particular case. So
Seems like quite the challenge.
It's a real problem in every single case. Anytime you have a company, if they're in a country where some countries' depositions are illegal, even if they're willing to send to the deposition, sit for it, you can't. They can get in trouble for it. They have to travel to another country where it is legal. It's a real problem.
I think it puts you right on the cusp of a conflict between how different legal systems have chosen to organize themselves, right? The US, you have incredibly wide discovery rules. UK has pretty broad ones, but then there are jurisdictions, European jurisdictions, with very narrow discovery rules. And these, whenever I represent large companies based in Europe, a lot of the discussion often is about why the English disclosure obligations are as wide as they are, because it's not what large multinationals based in Europe tend to be used to. And I think it comes as a shock to them when they discover the breadth of what's expected in the US, for example.
Yeah.
That's why when we do the 1782 work, which is discovery conducted in the United States for a case overseas, it's a separate filing with the U.S. court. It's almost always like, our lead counsel in the case are like, we can get that information. Like they're almost always shocked about the access to discovery that we have in the United States as compared to other places.
Do you think that ever impacts the decision about where to bring an action?
I mean, from the UK perspective, I think undoubtedly the UK is a claimant-friendly jurisdiction. It has a lot of features, including reasonably wide-ranging disclosure, not US style, but wide. It's difficult to knock claims out early on because claimants are generally able to say this is all very complicated and needs to go to trial, and will normally get traction with that. It's friendly to funding for the most part, even with PACAR. And I think those kinds of features of a regime do attract claims. Large damages awards are possible and feasible. And I think some of the things we heard from some of the panelists earlier about difficulties in France, for example, I think there's very clear advantages for claimants with some jurisdictions.
Great. I want to turn a little bit more to damages and talk a bit about how damages are managed, in particular with these larger mass actions where there might be differing fact patterns within the members of the group. Debbie, do you want to start there?
Well, I think if we're talking about something like a multi-district litigation that we started talking about a few minutes ago, I mentioned bellwether cases, and I know that there are a lot of views about that and whether they're useful or not useful, and then how you pick these cases. But there is there's certainly been used in this context, and by bellwether cases, basically we mean what are intended to be somewhat exemplar cases, a sample of cases that should tell you something more about the broader group of cases that you've got consolidated in the multi-district litigation, perhaps factions of those cases, because there might be different groupings of ways to group cases. But the concept is to pick a relatively small number of cases. Maybe you winnow it down from a bigger group that you start with. Do intensive discovery on those cases so that you have basically a trial-ready case, and then try those cases if you get that far. Sometimes things settle before you get to that point, before you get to the trial. But to get an understanding of how these cases are really going to fare in the trial system. That has been a process that's used. There's a lot of controversy over how you select the bellwether cases and from what pool you select the bellwether cases, and whether, in fact, it works. I know some judges who think it's just not a useful process at all, and others think it is more useful. To some extent, what I've observed is that it gets people to dig into the cases a bit more, and I think everybody gets a lot more knowledge about, what these cases really consist of. Because when you have 50, 60,000 cases, nobody knows them in detail at that point. They've just been filed. Yes, sir.
Debbie, thank you for your comments. If a judge is not in favor of a bellwether scenario, doesn't that by de facto mean that some other case is going to be tried anyway, and they will look to it as a bellwether anyway?
It may effectively become, and I'm not saying that they would refuse to do it. I've just heard some judges say, I just don't think it's that helpful, or, so it may not be that they're saying we're not going to do that. But yes, some case gets tried. So like the first Roundup case that got tried was, somebody, and Roundup is an herbicide that was widely used in the United States for many years, and then there were lots of litigation over it. And he was somebody who used it as a part of his job as I think it was a school system or something. He had to spray things and keep the weeds down and all of that. So yeah, that case got a huge verdict. It obviously sort of set a stage for additional cases to get tried, and it sort of serves that purpose in some sense, even if you haven't created a group of cases. But I think that case was just, the reason it went to trial was for exigent circumstances. I think he was very ill, and that's what happened. It was in California. So yes, you can effectively get that, but you have to have more than one case, I think, to get a little bit better picture, because the circumstances can be so different in these different, when you have so many cases consolidated.
Yeah. And I think, just to add, I think unfortunately it really is an incredibly flawed process. Obviously, defense lawyers, cover your ears, but it's obvious that we pick our best cases when you have the plaintiff selection, and then we know the defense team obviously picks our worst cases or what they think are our worst cases. I've had litigations before where we've conducted drafts like fantasy football, where you're ping-ponging back and forth. It's a real problem as well, because then you're not really getting like what a true value of a case might be in that scenario. And you try if you have 500 clients in a case, you try telling if you have 10 bellwethers from those 500, you try telling, the 11th client, hey, I'm sorry, your case, you don't have your day in court right now because you weren't selected. It's very difficult.
So I've been a special master in a case where I picked I didn't pick the bellwether cases. I picked the group of about 100 cases, and then I just did a random sample. It was totally random, numerical. Picked, 10 cases. No side got to pick.
Yeah.
So it's, it's just
hard.
different. It may still not be a good selection of.
Yeah, because if you look at 3M's a really good example of how it doesn't work, because you have one verdict where it's a defense verdict, and then the next verdict's for $1 billion,
Yeah.
and it's like, okay, well, where's the value there? How do you measure that?
50%.
Right.
So,
I'd be fine with that.
yeah.
Well, and I think another interesting concept here is, the number of data points you have to sort of retain about your clients, right, or about the members of the people that are participating in this. I mean, I've been doing this for 2 decades, and I watch like the software that we maintain and use with our clients to help them manage this process really evolve. And I wonder whether there's more opportunity there, because you can record so many data points now about people and slice and dice it. I mean, you as a neutral could ask for a sample of X number of people with these characteristics and select from that. And if you've got a good database that maintains that sort of in as factual way as possible.
The part you can't really look at is who these people really are. So when they come into court, when you get, on personal injury cases, you may get family members testifying and people like that. Some people do really well, some people don't, and you don't have that element, that factor. But yeah, you can certainly get the raw data without the flavor of it. But,
yeah. James, what about in the UK? How would you manage something like this?
So again, it's sort of up for grabs. There's different approaches, like having test claimants or sample claimants. I've heard it suggested in cases that the court should deal with the legal issues without any actual claimants and just sort of set out the principles and then let the parties try and figure it out from there. I think the last point you made about data collection is a really important one, because when you come to looking at which claimants are the right ones, you want to pick obviously a range of characteristics representative of at least the main constituents of the group. But if that data isn't collected up front, you have 100,000 claimants, for example, there's a huge backfilling exercise that needs to go on. And in an adverse cost jurisdiction like the UK, your defendant is not going to be happy about the claimants going out and spending 15 minutes or whatever with each of 100,000 people, because it causes the cost to spiral. And I think thinking about that end of the process up front is really important, so that you can make the decisions based on the right data that's already being collected. And I think that's something we're still learning about in our process.
Interesting. So talking about damages, the next logical step is settlement. I'd like to hear from the panel on what factors you think contribute to settlement in mass tort. Joshua, do you want to start?
Sure. I wrote it down. I think it was Matthew who said it during the last panel, and obviously not to call him out while he doesn't have a mic anymore, but he said for fighting it out, right, and determining whether to settle. And I think he said, if you believe in your product as a company, defend your product. And I to this day, I've never had, when I'm taking a deposition of a CEO or a 30B6 deposition, I've never had the CEOs turn to me and say, I don't believe in my product. It just doesn't happen. And I would venture to say a company even like Bayer, Monsanto probably still believes in Roundup, even after all of the evidence and the trials and the verdicts. So when you're thinking about settlement early on, and from it's really difficult in the mass tort complex. It's very rare where you have a case where you have a ton of claimants and you're getting a settlement right out. So you just have to duke it out, and it takes years. And explain that to clients is on our side, it's really hard, because you tell someone that you may not see a courtroom or any type of settlement for 5, 6, 7 years, and to them that's just impossible.
Yeah. Debbie, what about you? Thoughts on that? And I think we want to talk about the bankruptcy piece as well. I don't know if this is a good place to do that, but it might be.
In terms of what drives settlements, there's so many factors really that kind of are in play. In something as simple on the company side, you want to engage in a transaction with another company and you need to get rid of your liability. You might say, let's settle now. It's not even related to the trial coming up or anything like that. There's so many different issues that can affect it, but I think people need to understand how to settle. You don't know how to settle until you know something about how that litigation is going to proceed and what could happen and what the risks are. And if you're a defendant, you should be doing your risk analysis, and on the plaintiff side, you should be doing the same thing, really, to see how much is this going to cost me to go forward, and is it going to overwhelm the damages that I think I can get? And so it's, you kind of should be doing that sort of analysis, and that's why you need data, Loree just mentioned. But you just asked about the bankruptcy issue, and so there's, certainly a lot going on in the U.S. right now with mass tort bankruptcies, and there's certainly been a lot of mass tort bankruptcies. And in the bankruptcy process, you do corral all the cases, and you do have a procedure for resolving them through the bankruptcy case, and we can go into a whole ton of detail on that. But rather than do that, one of the issues that's front and center right now in the United States is the scope of your bankruptcy release, which is you know that the company that's the debtor will get a discharge in bankruptcy, assuming that they filed an appropriate bankruptcy case. But what's been happening for the last couple of decades is that other entities have been also getting releases in these bankruptcy cases. So parent companies and insurance companies and other kinds of entities in various ways can get releases, and now the Supreme Court has said, well, we're not going to allow non-consensual releases, which raises a whole host of questions about how these cases are going to get resolved. And I think it's important to mention this because a lot of the big cases in the U.S. that have, maybe some of them have started as multi-district litigation cases and they've moved into the bankruptcy process to get resolved. It's a pretty significant area, and it is going to affect, I think, what you talked about, cross-border, resolutions, because to the extent that a company could actually file their bankruptcy case in some other country and be successful and have less of a limitation than the U.S. is currently imposing, then they may be able to come here and get the bankruptcy recognized under Chapter 15. So there's, I think there'll be more exploration of that. It may not work in a lot of situations, but I think it seems like it's an area that's ripe for further analysis and investigation.
Well, I think the piece of that I find interesting too is how defendants can limit their liability through the bankruptcy, right? So the famous Texas two-step and spinning off, separate entities to go bankrupt while the parent remains active, right?
You restructure your company, then file one in bankruptcy. There's several, 3 maybe in the asbestos arena that are like that, and then of course talc is the big one, and so now they've sort of split off. Instead of the third attempt to go through that bankruptcy, they've split up. First of all, went to a different jurisdiction and split off the asbestos-related talc cases from the ovarian cancer cases. So there's sort of a different process going through. But yes, I don't know if you want to get into that at all. Maybe you want to talk about it. I don't know.
I have a lot of opinions on this, obviously. I will say, if from the company perspective, why would you not just create a shell company and then sell the product to that shell, and then know you have bankruptcy in your back pocket just in case things go south? Like it's another problem, and I gotta be careful with what I say. I don't think a bankruptcy court should be able to hijack a mass tort products liability, personal injury style case. It's not the proper place where they should be litigated. I understand the issues with it, but it's just not where our clients can get justice for their injuries.
I think if you look at the original opinion in the J&J case or LTL case, I think the bankruptcy judge basically approved that process, saying that it was just going to be the most fair way to get compensation to people, because everyone would be treated the same way. So when you're in a bankruptcy case, when you come out of bankruptcy, there's usually a trust that then administers claims, and people file their claims and get their payments. And of course, the big issue is how much money goes into the trust in the first place. But his opinion, if you read it, was all about the practicality. People will get money quicker, and they will get money. They'll be treated equally instead of randomly in the tort system, or where you might get different outcomes. I think that was sort of a multi-page, I don't remember how long that opinion was, but I think it boils down to that. So
yeah, and a Johnson & Johnson company shouldn't be able to declare bankruptcy. I mean, someone can look it up, whatever their revenue is, billions. So that's the issue, obviously, we have on my side with it.
For an outside perspective, we don't have companies putting themselves into bankruptcy to avoid.
You answered the question I was going to ask
you. But it does strike me, just thinking about the discussion that Josh and Deborah have just had, that part of the issue is that there's a system in play where companies are exposed to potentially millions of dollars of damages on a per claimant basis in a system that, with jury awards and things, perhaps lacks a degree of predictability. And where companies are faced with 10, 20, 30 plus $1 billion of liabilities, I mean, it's no wonder that they look for creative solutions for how they can manage and mitigate those risks. And I don't think that's necessarily sort of corporate bad play. It's more the issue is so large and so it's potentially damaging to their business model that they're forced to sort of think about how do they deal with this huge unknown.
Oh yeah, I don't blame them for doing. I would do it too if I was on their side. And what do they care about? They care about their ticker and stock prices. And from my perspective, it's really our judicial system in the United States that's permitting this to happen. That's the real issue. I don't blame Johnson & Johnson or any company for trying the bankruptcy route because they know it's much more effective on their side.
Yeah, but I think if you go the other route and you have ovarian cancer is like 30,000 people a year, I think, get contracted. And I think, so you cannot try all those cases. It can't possibly go through the normal system. And that's part of the problem everybody's facing here with how do you deal with that? Because it's a stream that's going to keep going.
Right, but from our perspective, clients should not be shut out inherently from that process. The whole point of the judicial system is for people, courts are supposed to be open. Every judge will tell you that, so a client should be able to, or plaintiff should be able to file a case and not be totally shut out of that process because a shell company was created and they decide to declare bankruptcy.
You can't in bankruptcy, you can't extinguish the jury trial right. So in a bankruptcy, every bankruptcy plan with mass tort bankruptcy plan has some process where you ultimately can get to a jury trial. Now, some of them have many steps in front of that, so it takes years to get to that point. But they're not all set up like that. But they do. You ultimately have to have, for a personal injury case, you ultimately have to have that.
Right, and that's the issue. It stays the case for such a long period of time where it's effectively shutting them out.
Yeah.
So James, circling back to you really quickly, I mean, in your jurisdiction, what happens when a defendant becomes insolvent and there are claims like this pending?
Joe, I'm not aware of any large situations where it's happened, possibly because of a combination of maybe the development of the regime on a slower track, combined with its claims tend to target large, pretty solvent companies. So I can't, and people in the audience may have examples, but I actually can't think of one. The claim would, I suppose, disappear into the bankruptcy process and be dealt with like all other unsecured claims in English bankruptcy, which isn't a very attractive place to be.
Yeah. Maybe we see more of those coming. I did want to circle back with you on one other point, which was just the prior question about what factors you think lead to when and how a mass tort settles, so just from the perspective of your jurisdiction.
Yeah, it's a really good question. I think number of observations. Firstly, I agree with what Josh said. I think it can be really difficult, particularly where there's a lack of obvious clarity about which way the case is going to go, and these things take a long time to get down to people having a really good understanding of the merits and enough understanding of the merits to get really realistic legal advice about what the risks are. I think that time factor is then complicated by the role of litigation funders, ATE insurers, capital protection providers, and all the rest of it, because what I've seen in a number of cases is, as the ball kind of rolls on, you end up in a situation where cases effectively become unsettleable because there are too many pockets to fill before the claimants are getting anything, and where views of the value of the case diverge significantly, it becomes really difficult. So I haven't sort of told you what factors I think achieve a settlement, but things I think inhibit it. Mm-hmm. I think it's an area where there's real scope for everybody, all the stakeholders at the table, to think long and hard about what they can do to actually move it forward and get to quicker outcomes.
Makes sense. So in the interest of time and being cognizant of the fact that we stand between you and lunch, I'm going to turn it over to the panelists for any final comments, then maybe we can use the last couple of minutes for questions. So Josh, start with you.
I'd find just opening up to questions. So I feel like people probably have a lot. I've said a couple things that I'm sure people disagree with. So if anyone has questions, we could do that too.
Yeah. Any final points either of you want to make?
I had one point, which is when you're talking about the timing of settlement, but you also have to think about what the settlement is. And we're talking here, I'm talking more about cases that involve personal injuries and not consumer product defect kinds of cases. So one of the things that I think, from my perspective, having dealt with this for a long time, one of the things that's most important is you really better know your audience. You better know who these claimants are, whether it's a class or some other kind of formulation, because your settlement design may not fit your population, and you may find that they can't actually meet the criteria, or they can't produce the kinds of documentation that you're asking them to produce, or they might not understand it. We talked about notice yesterday. It's sometimes very difficult to explain a very complex and nuanced settlement to people. It's even the lawyers don't always understand it fully. And so if you don't know who you're dealing with and you design a settlement that doesn't match that population, you will have infinite problems trying to implement it. And I'm just mentioning that because it's when you get to the idea of you can settle, then you have to decide what your settlement's going to look like. So
Yeah, no, I think that's a very valid point. I mean, as a settlement administrator, we've definitely seen many settlements that are not architected to speak to the class for which they serve, and that can be quite the challenge, both from a cost perspective, from a participation perspective. So that's a very good point to make. Any final points from you, James, or should we turn it over to questions?
I think just one further thought on settlement. Yeah, often it's triggered, or the discussions are triggered by having gone through the procedural scrapping. You know, and English litigation is very susceptible to early stage procedural fights, and actually those things do need to be moved through first. So the opportunity is, you know, spotting when they come up and taking advantage of the moment when it's there is obviously very important. But it does require a little bit of trench warfare first, I think. Yeah.
That's the fun part, right? All right. Thanks very much to the panelists. We can open it up for questions now.
no questions.
Hi. I mentioned in my introduction the Duane Morris report into tort and mass tort and product liability was $50 billion in 2022, but that number had halved to 2023. And although this year, at the halfway point, it was slightly trending back up, it was still on track to only be about 2/3 of where it was 2 years ago. So I just wondered if there was any of the panel had a view on why that overall value had declined slightly in recent years.
I missed what was the first part of that question? I'm sorry.
The Duane Morris report on mass tort and product liability said that those claims are worth a combined $50 billion in 2022. Yeah. That number halved in 2023 and is trending slightly back up this year, but is still only about 2/3. On track to be about 2/3.
So that's just Duane Morris's own internal.
Yeah, there's a report they published.
I would say, you know, there is a little bit of a change right now in the mass tort world. As far as the types of cases that are getting filed, and a lot of firms like mine are working up cases outside of your typical MDL process. We find the best value for our clients in individually working that case up. And so, you know, for example, we're in Philadelphia. I think many people know Philadelphia is, and state court there is one of the best jurisdictions to be if you're a plaintiff's lawyer, and one of the worst if you're a corporation because of the verdicts. And so we try to file as much as we can in that state, and thanks to the Mallory decision and Keller Postman really spearheaded that. Pennsylvania's a consent jurisdiction statute, has it, so if you do business in the state, you can be held, you can have personal jurisdiction against the company there. So that's probably related to, just to bring it full circle, it's probably related to the fact that people aren't doing, plaintiffs' firms aren't doing their standard MDL style mass torts, and they're filing their cases more individually.
Any other thoughts on that? Yeah, I mean, I think in our mass tort practice in the U.S., we handle the settlements of those as well, and I don't know that we've seen like a concurrent rise and fall in business, so it may just be the data sources aren't all publicly available. Yeah. Any other questions from the audience? Nope. All right. Well, thanks very much to the panel. If you could join me in thanking them, and we're off to lunch.